It's now 9 o'clock, so let's go on the record. Today's date is July 20th of 2023, and the current time is 9 a.m. We are conducting this rulemaking hearing from room 310 of the Governor Office Building, and some parties will also be participating via WebEx. The Commission has set aside this time for a rule comment hearing in the file captioned as in the matter of a proposed rulemaking to promulgate a new rule regarding a residential customer disconnection data reporting rule. And that is file number AX-2023-0175. These rules were published in the Missouri Register on June 15th, 2023, volume 48, number 12, and those are pages 1025 and 1026. The subject of this rulemaking hearing is the proposed rule, or Commission Rule 20 CSR 4240-13.075, service disconnection reporting requirements for electric, gas, sewer, and water utilities. At this time, I'm going to remind the parties, anybody who's speaking, who's in the room here in Jefferson City, to use the microphone, and be sure your microphone is on when you're speaking and off when you're not. Likewise, if you're participating via WebEx, I would ask that you keep yourself muted until such time as you are offering comments or need to speak. If you are appearing via WebEx, everything that is being said is being taken down by a court reporter, and because that court reporter is not familiar with everybody who is going to be on WebEx, I'm going to ask that if you're making WebEx comments, that you identify yourself before making your comment. My name is John Clark, and I'm the regulatory law judge overseeing this hearing today. I'm going to begin by asking the attorneys who are here to enter their appearance, and I will start with the Commission staff.
Eric Vandergriff with staff.
I don't think your microphone's on.
Eric Vandergriff with staff. The reporter already has my address.
Thank you, Mr. Vandergriff. On behalf of OPC, or the Office of Public Counsel.
Lindsay Van Gerpen on behalf of the Office of the Public Counsel, and the court reporter also has my address.
Thank you, Ms. Van Gerpen. On behalf of Missouri American Water Company.
Good morning, Rachel Niemeyer on behalf of Missouri American Water Company. The court reporter also has our information.
Thank you. On behalf of Ameren, Missouri.
Good morning, Jermaine Grubbs on behalf of Ameren, Missouri. My business address is 1901 Choteau Avenue in St. Louis, Missouri, 63103. Thank you.
Thank you. What companies have I missed?
Judge, on behalf of the Evergy companies, my name is James Fisher with the law firm of Fisher and Doherty PC. Our address is 2081 Honeysuckle Lane, Jefferson City, Missouri, 65101. I'm sorry, 109.
Thank you, Mr. Fisher.
And this is Diana Carter, appearing for the Empire District Electric Company, the Empire District Gas Company, Liberty Utilities, Mid-States Natural Gas Corp., and Liberty Utilities Missouri Water, LLC, all of which do business as Liberty.
Thank you, Ms. Carter. And there are a couple of non-company entities who are participating today. Mr. Kaufman?
Good morning, Your Honor. John B. Kaufman on behalf of the Consumers Council of Missouri. My address is 871 Tuxedo Boulevard, St. Louis, Missouri, 63119.
Thank you, Mr. Kaufman. Have I missed anyone? Okay. This is not a contested...
Hi,
Go ahead, please.
it's Philip Persig. I'm here representing Renew Missouri. We're at 915 East Ash Street, Columbia, Missouri, 65201. And my name is spelled PHILIPFRACICA. Thank you.
Thank you. Now, this is not a contested case, so there's no cross-examination from the parties. The commission or myself may ask questions. If any commissioners have questions, I'm not going to really pause to take questions, so just let me know verbally that you have a question to ask, and we can go ahead and ask that, or just go ahead and ask your question. Now, as you're providing comments, please be sure to state your name and position. Now, pursuant to Commission Rule 20 CSR 4240-2.1808D, comments will be taken from those supporting the proposed rule, followed by those opposing the proposed rule, unless the presiding officer says otherwise, which I don't. So, is there anybody, just so I have a rough feel for this, is there anybody here who's offering comments today in opposition to this rule? Okay, nobody appears to be, so I will just take comments. Why don't we start with, I think traditionally the commission staff has gone last. Is that correct? Okay. Why don't we start with the Office of the Public Counsel?
Your Honor, would you like me to go up to the stand?
Are you testifying or just making comments?
Testifying.
If you're testifying, you can come up to the witness box.
If you want, I'd be fine going up to the podium. Done that before.
That would be fine. If you're more comfortable at the podium, I'm fine with that.
Thank you. Good morning. My name is Jeff Mark. Oh,
Do you swear or affirm that the testimony you're about to give at this rulemaking hearing is the truth?
it is.
Thank you. Please go ahead.
Good morning. My name is Jeff Mark. I'm the Chief Economist with Missouri Office of Public Counsel. Thank everybody for showing up today. This was a rule-making initiative instituted by the Office of Public Counsel 1,333 days ago. My comments today are going to be in 4 parts. Just to level set for the audience that may not have been present 3.5 months ago, or 3 years and 3.5 years ago, how we got here. Part 1, Part 2, what we did in that intermediate period. Part 3, the current economic status facing customers today. And finally, we're going to respond to some of the comments that have been filed in EFIS. So on November 25th, 2019, the Office of Public Counsel filed a petition to go ahead and open up a working docket to discuss data disconnection standardization practices across our utilities. Specifically, and I'm going to read our first page. The OPC attempted to answer a series of questions that was posed to us by the National Consumer Law Center, or NCLC, in anticipation of a series of webinars hosted by the National Regulatory Research Institute and the National Association of Regulatory Utility Commissioners, a committee on consumer and public interest regarding delinquencies and disconnections. Those questions could be summarized as follows. 1, do utilities report the number of involuntary disconnections? 2, is that information publicly available? 3, have the number of disconnects reported by the utilities changed over time? And finally, if yes, how have they changed? In an attempt to answer those aforementioned questions and understand customer disconnection numbers and patterns across Missouri, utilities, and across time, the OPC reviewed and consolidated each electric, gas, and large water utility non-case related submissions of annual reports in the Commission's EFIS as it pertains to disconnections and bill assistance from 2009 to the present, so 10 years worth of data. Based on our research, OPC concluded that the electric and gas utilities, but not water, do report the number of disconnections in at least 2 periodic filings with the Commission, the annual report and the monthly cold weather reports. However, the disconnect numbers were not the same when examined on a year-to-year basis within utilities and across utilities. The utility disconnection information was not easily accessible to the public and in some cases had been designated as confidential. The number of disconnections had changed considerably over time, but the reported number of disconnects depended on the filing, year, and company varied considerably. And based on the consolidated filing, there does not appear to be an agreed-to standardization of data. Consequently, despite over a decade of collected data, no definitive statements about customer disconnections can be made as it appears how a disconnect is counted varies considerably across utilities. The Public Council opened up, we had a series of workshops with stakeholders from Ameren Electric and Gas, Evergy Metro and West, Liberty Gas, Electric and Water, Spire East, Spire West, Summit Natural Gas, Missouri American Water, Central States Water Resources, and Raytown Water. The two workshops were a collaborative process. I can say my career in this field, it was probably one of the more cohesive events of herding cats that I've ever experienced. Everybody recognized the problem, and we worked together as well as could be expected in the middle of COVID, remotely, to try to come to agreed to outcomes. And I think it's a testament to what you've already heard today, that no party is contesting these rules. We also instituted a voluntary one-month case study, which about more than half of the utilities took up with our office. And we had individual meetings and follow-ups with utilities based off of feedback that we received. To provide, this was also, and it goes without saying, there was a resolution passed by NARUC in 2019 that became the basis for the movement within these rules. To provide a little context on, finally, on the economic status of what we're looking for, the U.S. uses a number of different measures, whether it's U.S. Census data, American Community Survey data, a variety of different poverty measures that exist, whether that's Murta-Sen's index, squared poverty gap indexes, high-frequency poverty measures. There's one number that I like to rely on to serve as sort of a barometer of what we're looking at in terms of the economy that I think is very telling. And it's the Federal Reserve's annual report on economic well-being of U.S. households. What the Fed does is they effectively do a large-scale survey across the United States asking if adults could cover $400 of an emergency using cash or an equivalent method. So $400. The most recent study suggests that 37% of adults could not cover a $400 expense. And these numbers are even more pronounced across race and ethnicity. For example, Asians, it's 18%, for Caucasian, 29%, for Hispanic, 53%, for African American, 57%. And perhaps not surprisingly, it's more pronounced with adults with children. 43% of adults with children could not cover a $400 emergency expense, compared to 37% of adults that do not have children. The rural-urban gap is also pronounced. 45% of rural respondents could not cover a $400 emergency, whereas 36% of urban respondents could not do that. Following COVID and an influx of subsidies that occurred to go ahead and prop up the economy that are now dying out, including probably most notably LIWAP assistance for water, which in Missouri, applications ceased in June of this year, and funding is expected to cease in September of this year. The need to record and to effectively have a canary in the coal mine to gauge the status and health of our customers is all the more important. This is coupled with year-over-year increases in capital expenditures by utilities through enabling legislation like PISA, ISRIS, WISRA. And volatile fuel costs that are taking place right now. Finally, I'd point out that Americans have nearly $1 trillion in credit card debt, which is exacerbated at the moment with higher interest rates. And what's gotten a fair amount of press, $1.78 trillion in student debt. For all of those reasons, we believe it's important to have measures in place to inform the public and the stakeholders involved in being able to allocate funds appropriately and to drive effective public policy. I'd like to comment finally on comments that were filed in this case today. It effectively followed a variety of different formats. In regards to variance request made by some utilities, we'd point out that the variance rule already exists within the commission rules. Putting in an additional language within the section here would just be redundant. On that note, to the extent that the commission does grant a variance to a utility, we recommend that it be on a very temporal basis or short term. Requiring a variance, from a utility from this rule entirely would defeat the purpose of being able to provide this information. In regards to the staff's request for cold weather rule to continue maintaining that data, we don't object to that. It was not included in the current drafted rules in part because of feedback that we got from stakeholders that the information would be redundant. In terms of whether or not this would require an undue burden on utilities, or perhaps I misspoke, undue burden isn't the right choice of words, but I think the example was given that a full-time employee might need to be hired to deal with this data. We would respectfully disagree. We believe that, and based off of our experience with working with case studies with the utilities, effectively a little bit of hand-holding was needed and familiarity with the process the first time around. But effectively, after that's in place, it should be fairly easy to implement or to at least follow through thereafter. There have been a number of comments suggesting that the information be more finite in nature. The first one would be distinguishing between utility sections. So an example might be Spire West versus Spire East, and all the way down to postal zip code data. On this note, as a general rule and within a vacuum, we would absolutely agree that more finite data is better, all things being equal. Being able to know if a certain section of the state is being negatively impacted is extremely important from our perspective in terms of being able to allocate funds and work with community action agencies and other social service programs to direct funding appropriately. There has been a concern, I think, from our office in terms of potential privacy issues and simplicity and nature of the utilities being able to disseminate this information on the Commission's website. To that end, we would recommend that the monthly disconnection data that these rules envision putting on the Commission's website be fairly simple. That we limit it to voluntary and involuntary disconnections, but that additional information on a more finite basis on postal data or zip code data be information that we would not object to being filed with the Commission. I think the issue comes down to who would have access to that information. It does very little for other interveners like that are stakeholders for low-income or low-income advocates not having access to that information. To that end, we would like to hear the feedback from other speakers today before we reserve an additional comment, I think maybe even later, or hopefully take a second bite at the apple during this public hearing. But we, again, I would stress that on a whole, we appreciate and understand the importance of it. I think the issue just, again, comes down to privacy concerns, where hopefully we can find a path forward as far as that's concerned. I'll pause here if anybody has any questions.
I have just a couple for you. You had mentioned that a variance was unnecessary for this, you felt, and without looking, because I don't know off the top of my head, does Chapter 13 already contain a variance in it?
I'm going to defer to my legal counsel or Ms. Contessa King, who might know.
Your Honor, Chapter 13 does not include a general variance provision, but it is included in Chapter 2. And I apologize, I don't have that exact rule with me. But it is a general variance provision and says the Commission can grant a variance or waiver from any Commission rule.
Okay, thank you very much.
Judge, if I may.
Go ahead.
Contessa King, Contessa, last name King, King. I am the manager of the Customer Experience Department. And I just wanted to mention that there is a section in Chapter 13. It's 13.065, and it is called variance. Whenever a utility is requesting a variance from anything in Chapter 13, this kind of lays out kind of the provisions for that.
Thank you, Ms. King.
You're welcome.
My next question involves a filing, Evergy's comments filed in this case. They filed a proposed format for the information. Did you have an opportunity to look at that?
We did.
And did OPC have anything they wanted to say in regards to that formula? Is that something, or that format, is that something that would be, is that along the lines of what public counsel envisioned?
It was not. And again, most of this was based off of feedback of trying to appease multiple different utilities in terms of the information that was provided. My understanding, and my legal counsel might be able to expound on that if need be, that we're at this stage of the game after 3.5 years, the feedback that we've gotten was to move forward with what we had drafted.
Is there a particular format contemplated?
Judge Clark, if I could jump in here. So the format that Evergy provided, which was just a simple, I believe it was originally given in an Excel format, I think that is close to what we're envisioning. The rule specifies that the data should be provided in an Excel format with any, I'm just making sure, in a native electronic spreadsheet format with all links and formulas intact. And I believe that is how it was originally provided to us. So if we're just looking at the format, I think that was something.
I stand corrected. If the question is just the format, then yeah.
Okay, thank you. And you're going to hear me ask this next question a lot, and that is, rulemakings require that you submit both a public and a private cost, and those currently, as it was submitted, were estimated at $0 or below $500. And that's total, that's not annually, that's over the entire lifetime of the rule. You had indicated that you disagreed that this would require that utilities hire a additional person to manage this. Has public counsel got an estimate or guess as to what the public and private costs of this would be for utilities?
My understanding would be under $500. I mean, effectively, the information is already being collected by the utilities based off of feedback and again, affirmation from the utilities that they could provide the information in the format that we saw. We looked at this as a job or a function that would be allocated to existing personnel. Again, utilities have been required to file disconnection information in 2 separate filings for the commission for over a decade now. The problem at hand here is that information really hadn't been checked and cross-checked. And when we did look at that information, it didn't make sense. We couldn't form any basis for the wild fluctuations between the 2 sets of data and within utilities over time. So it really is the exact same function. It's just trying to standardize how that's coming across and being reported to the commission.
So what you're telling me is that this information is already collected by the utility and broken down in the way that would be easy to respond to this rule?
We believe so.
Okay, I have no further questions. Thank you for your testimony.
Before I leave, I just wanted to express my gratitude to all the parties that participated in this. This is not an easy process, especially with trying to execute this through COVID. Putting on a full workshop remotely with, I think we had close to 65 people on our first call, trying to navigate the rules was quite the endeavor, and it really took a lot of patience from the utility. So hats off to them. Thank you.
Thank you, Dr. Mark. Missouri American Water Company, do you have any comments today?
Good morning, Judge. Rachel Niemeyer on behalf of Missouri American Water Company. We filed our comments and we don't really have anything further to add unless there are questions from the bench or the commissioners. We would add only that we support Liberty's proposal for a delay between the adoption of the rule and the implementation, because it is something that we will have to program and work with the Office of Public Counsel and staff to ensure that the formatting is correct. And we have to have the personnel to be able to do that. I would respond to Mr. Mark's comments about the cost, that this information isn't being collected in the way that it's being proposed to be presented in this proceeding, or I don't know that there would be a need for this proceeding. And so the specifics of that are unknown, and the time that it will take are unknown, but it's certainly going to take some time for somebody to pull that information, gather it, go through and make sure that the personal information is removed, and then filing the document. So we do not believe that it would not exceed 500 for all the utilities to do that.
Would you say that last line again, please?
We do not agree that, so we think it would exceed $500 for all of the utilities to implement this rule. What the actual cost is, we don't know at this time.
And I will note that Dr. Mark had indicated that this information appeared to be compiled by other utilities already, but not so much by water utilities. Is that correct?
That is correct.
Do you have any estimation or even guess as to what the cost to Missouri American Water Company would be?
At this point, we don't have anything beyond what we included in our comments, because this would be a new report for us, and it's not worth the cost for experimentation if it doesn't get implemented and go through the formal process. So we don't have any specific information to answer that question at this time.
Do you think it would require a full-time employee's a full day of work?
We think it is possible that it would take a full-time employee or would add to 25% to 100% of someone's time, especially if you add this to all the other reporting that Missouri American does.
Okay, thank you for your comments.
You're welcome. Thank you for the time. We appreciate the opportunity to participate.
Does Ameren, Missouri have any comments in regard to this rulemaking?
Yes, Your Honor, thank you. Jermaine Grubbs, appearing on behalf of Ameren, Missouri. I am joined by Aubrey Krishmar, who is a regulatory liaison for Ameren, Missouri. First off, I want to express appreciation on behalf of Ameren, Missouri for the opportunity to participate not only throughout this rulemaking docket, but the prior working docket as well, and echo OPC's appreciation for everyone's efforts on this important rulemaking. So I would like to clarify a couple of comments that were filed last week and I guess early this week. So I would note Ameren, Missouri supports Liberty's point that delaying the comments between the adoption of the new rule and the due date for the submission of the first report under the new rule will allow configuration of queries for the reporting, making sure that we have the formatting that OPC and others are expecting, those sorts of things. And from Ameren's perspective, we're estimating approximately 90 days would be sufficient for that. I would note that Ameren, Missouri does not support staff's suggested addition to require the duplicative types of reporting under the cold weather rule for the cold weather rule reporting. So that basically you'd have the duplication of, you'd have similar but not necessarily apples to apples comparable data under the cold weather rule, and then a separate report under this new rule. So we would not express support of that change. Ameren, Missouri also does not support, I believe it was Sierra Club, Consumers Council of Missouri, and Professor Kaniski, and I apologize if I mispronounced the professor's name, but they suggested addition of another provision to provide some data by zip code, or I believe Professor Kaniski's proposal was to provide at the census block level. Ameren, Missouri would have to try to develop, special analysis to provide any information by zip code. And from what I understand from our technical folks, we do not store data by census block, and there could be some concerns about the accuracy of the geo-coordinates, especially in our more rural areas that are served. It may not be great, so not sure that by census block is workable, or not, at least to a level of accuracy that would likely be expected. I would also want to clarify, I believe in Dr. Mark's testimony earlier today, he did mention or reference the annual report versus the monthly cold weather reporting, and may have described that as there were inconsistencies or inaccuracies. I believe Ameren, Missouri, in our initial comments in the working docket, did clarify that the annual report includes a different slice of information. The annual report includes disconnections for both residential and non-residential customers, whereas the cold weather rule reporting only provides residential disconnection information. So just wanted to clarify that, again, for the record here. And then on, I believe the question arose about the public or private cost of the rule. I would note that in Ameren, Missouri's initial comments filed in the AW, the working docket that preceded this, which we filed those comments on February 14th of 2020. In there at that time, based on that version of the proposed rule, we estimated that the cost would be between $8,000 and $15,000. I don't have a more updated estimate for you today, especially as we try to figure out what the final rule is actually going to look like. So we would continue to say, at least currently, our estimate is between $8,000 and $15,000. It would really be, the basis for that is there's digital time, or IT to program the querying of the system, so that programming time. So it would likely be more of an upfront cost, and then there would be, for the monthly pulling of that, some time for employees to do that. So I appreciate the opportunity to make these comments on behalf of Ameren, Missouri, and we'll try to address any questions.
Now, in regard to that $8,000 to $15,000 that the company is estimating, is that over the lifetime of the rule, or is that an annual cost? You indicated that the bulk of the cost would be up front.
So I believe that the $8,000, the lower end of the range, was that IT and kind of the upfront, and we were not sure what the monthly expense would be for that, and so kind of gave that range, at least for that first year of implementation, thought that the 8 to 15 captured it. So not over the life of the rule, but probably that first year at least.
What kind of employee time do you believe would be necessary each year once those upfront IT concerns are, the ability to query the system, as you said?
So then on a monthly basis, I believe there would be, an individual internally who would then run the queries. There would then be a handoff for the actual submission of the report. So if that on a monthly basis is, I don't have a firm answer from the IT group. I would estimate that it was, less than 10 hours. And so then if that was as a monthly report, so times 12, I would suggest it would likely be less than 120 hours a year, but I'm sorry, that's a very, very rough estimates.
I believe all that's sort of required is an estimate, so thank you.
Judge, if you may, quick response to that.
That'd be fine.
I'm not contesting anything Ms. Grubb said. Appreciate her insight with this. I would point out that Ameren was one of the case studies that we worked with and was able to produce the information to public counsel in a timely fashion already.
Thank you. And are there any questions for Ms. Grubbs from the commission? Ms. Grubbs, was Ms. Kirchmeier going to be testifying today?
No, Your Honor.
I have no further questions for you. Thank you for your comments. Are there any comments from Evergy, Missouri?
Just briefly, Judge, this is Jim Fisher, Fischer. The Evergy companies did participate in the workshops and appreciated very much the efforts of all the parties to work together to come to a resolution of it. We filed comments on July 14th, and I really don't have much to add there. In those comments, we indicated the companies could comply with the proposed rule as long as they were using a format like we had suggested. And as I understood public counsel's comments, they were okay with that, although they wanted the Excel formulas intact so they could do some analysis. We often provide that as a part of discovery, so I don't think that'll be a problem. There were some comments filed regarding providing the data by zip code. We didn't specifically analyze all of that. In other contexts, we've found that sometimes it is difficult to provide some data along that line by zip code, and I think we'd be concerned if that was added to the rule. But with that, unless you have questions, I don't have anything else.
Well, you've had an opportunity so far to hear. As I indicated, you'll hear me ask about costs a lot. Does Evergy have an estimation as to the cost of compliance with this rule?
I unfortunately don't have that number. I can try to provide that to you at a later date. Or not.
I don't know if that will be necessary, but I will let you know. I think after this hearing today, we're beyond the comment period, so. Thank you, Mr. Fisher. Are there any questions for Mr. Fisher or for Evergy? Does Liberty, Missouri have any comments regarding this rule?
Hi, Judge. Thank you. This is Diana Carter. We filed written comments on behalf of the 4 Liberty utilities operating in Missouri, and I'm available to answer any questions there may be on those comments. And Haley Sermon, our Director of Customer Experience, is also available on the line. We're supportive of the rule with 2 conditions: that utilities be able to obtain variances when necessary for good cause shown. And as Ms. King pointed out, there is the Chapter 13 provision on variances. There's also the Chapter 2 provision on variances. So I don't believe any additional language is needed. We just wanted to note that for the stakeholders and for the commission. And then we also think it will be important that the first report, that there is a delay between implementation of the rule and the due date for the first report, to allow the utilities to gather the data and get the process going. For Liberty, we would give a rough estimate, and that is truly a very rough estimate, of $5,000, possibly in upfront costs. We know we will have to write new reports to gather this data and provide it across all of the Liberty utilities.
Okay, thank you. And did your witness want to testify today, or just available to answer questions?
Just available if necessary. Thank you.
Okay, thank you, Ms. Carter. You've answered all my questions on behalf of Liberty. Are there any commission questions for Liberty? Okay. Comments from Consumers Council of Missouri.
Thank you, Your Honor. Can you hear me?
Yes, Mr. Kaufman, go ahead.
Yes, just briefly, we have filed written comments, but I wanted to emphasize a couple of points. First of all, we believe that this data is extremely important and is really at the core of the public protections that the PSC is here for. And we would point out that utility disconnections can lead to serious health risks, especially for seniors and people with disabilities. Utility disconnections have been proven in multiple studies to create barriers for children in educational learning. Disconnections have been proven to be linked to emergency room visits and serious educational serious health issues, as well as mobility issues, all of these social problems that are related to people being forced out of their home. For many people, a disconnection is also an eviction notice. And so it's really at the center of many issues that as a society we are wrestling with. And that's why starting with good, trustworthy data that is comparable from one utility to the next and from 1 year to the next is really important for the commission to be able to have informed decision-making and to really have a good gauge of how serious a problem is at any point. So we very much support the rule, and we praise the staff and the Office of the Public Counsel for working for this. This has been a goal of the commission, at least since 1977, when the cold weather rule was first put into place. And as it has been carefully documented by OPC and Jeff Mark, the data really has not been that useful, unfortunately. And the reason is because different utilities have interpreted it differently. They have complied with a variety of different formats, and the rule itself, as currently written and has been in place since 1977, is inadequate. So we really think that the draft rule as written will help and hopefully get this reporting to a point where the commission can get a good snapshot of how critical utility disconnection data is and what's going on with that. The second problem that this rule would correct is that there has been a lot of confusion about whether this is even public information. Unfortunately, because the current rule says that the data in the cold weather rule, the data is provided to staff and public counsel, there has been an argument made that that is not necessarily public information, could not be obtained through a sunshine request or through other means. It often finds its way into the public data. So the fact that this data would be posted on the commission's website is good, and we're really glad that that has been updated. We have one more suggestion that we think would be helpful, especially if this rule is going to be in effect for 10, 20, 30, 50 more years. We think that the addition of zip code data is pretty important. It has already become a granular feature of much of the data that the major regulated utilities in Missouri have done. I have no doubt that utilities are able to produce information about their customers on a zip code basis. We are specifically asking that you do a 5-digit zip code, not a 10-digit zip code. And that's because at some point, if you go to that level, the 10-digit postal code, there sometimes are only 1 or 2 customers there. We think that doing it by the 5-digit zip code will keep the information from revealing any private information, but give the kind of localized data that the commission, I think, would want to see, so as to know if there was a particular region or city or neighborhood that was facing a problem. It would help community action agencies, other agencies in the state, begin to focus in on where there might be a problem with poverty or with public health risk. So we're hoping that the commission at least requires this data to be at the granular level of 5-digit zip codes. We have suggested one way that that could be done in our comments, and so that amendment it would be only applied to the subsections that deal with disconnections themselves and not necessarily arrearages. But that is something that I think the commission will be glad that they did a few years down the road, if not decades down the road, so that we don't have another generation of disagreeing and mismatched data and not having the data that would really be helpful. I agree with the utilities that it would be good to have a little bit of lead time, a couple of months or so to let them adapt to the new format. That's not a problem. We do have some concern about the idea of using variances. Obviously, there's no need for a variance procedure. There's one in Chapter 13, there's one in Chapter 2. But if the utilities are allowed to get waivers from any particular provision on an ongoing basis, it would defeat the rule. So we do hope that the commission will insist that each of the utilities provide the data in a consistent format so that we finally have a good official gauge of what's going on generally. So I understand they have a right to ask for a variance, but hopefully that would be very narrow and very short in time if any such variance was granted. So that is essentially our comments, and we thank the commission for having this hearing. I'll take any questions or.
Thank you, Consumers Counsel. I don't have any questions for you, but it looks like Dr. Mark may have a comment that he wants to make.
Yep. Thank you, Judge. Mr. Kaufman, I've got David Koinski, who's contacted me, that has a brief window to opine on this, if that's acceptable. He's online right now.
Say that again, please.
Dr. David Koinski from the University of Indiana has contacted me just now and asked, he's got a brief window to speak up on this rulemaking, if that works for you.
Are there any objections to, I'm going to butcher his name if I try and say
I butchered it too.
Is there any objection to taking the professor's comments now?
No objections from staff, Your Honor.
Okay, I see and hear no other objections. Professor, are you on the WebEx?
I am.
Would you please,
Good morning.
would you please state and spell your name, and then you may offer your comments.
I will. Good morning. Thank you, Your Honor. My name is David Koniski, Konisky. I'm a professor at Indiana University at the Paul H. O'Neill School of Public and Environmental Affairs, where I also co-direct our Energy Justice Lab. Thanks for the opportunity. I will keep my comments brief, and I am grateful for you accommodating my schedule this morning. First thing to say is I strongly endorse this rule. We have been studying energy insecurity in particular and the problem of utility disconnections for many years. It is extremely important, and rulemakings like this go a long way to helping us understand the nature of the problem and who's most affected by these challenges. I'd like to make three very brief comments. I filed comments for the record, so I'm obviously happy to answer any questions about those, but I just wanted to underscore 3 points. First, in our work on energy insecurity, we have learned that challenges people have paying their energy bills, whether it's electricity, natural gas, are quite ubiquitous. By the best data we have, maybe 1 in 4 families struggle every year paying their energy bills, and thereby are subject to risks of utility disconnections. We know that this leads to all sorts of difficulties, not just in terms of material hardship, but also physical and mental health effects as well. Importantly, there are really well-documented disparities in who experiences these kinds of utility insecurity. We know people of color, households of low income, families with children, those who are medically compromised are all more likely to experience this. So that's the first thing to say. The second thing to say is that currently there are no nationally consistent data provided to allow us to understand this problem. So rulemakings like these are essential at the state level for requiring utilities to disclose more about disconnections, arrearages, and other types of challenges in this space. As I'm sure everybody in the room knows, we had more reporting done during the COVID pandemic, which was quite helpful. But rulemakings like this will allow us to better understand these data and better understand these situations. And there really is no substitute for these kinds of disclosure requirements. The last thing I want to quickly say is that the rulemaking proposed here is very consistent with what other places have done. Utilities have been required in many other states, not just during COVID, but going forward to report similar data. In some cases, this has been done historically. In other cases, this is a newer phenomenon, but this has been shown to be possible and quite informative. I want to comment briefly on the issue of geographic granularity. While it is most common for disclosure requirements to be asked for at the utility service territory level, it is extremely important that we have more geographically granular data to understand demographic and socioeconomic patterns of arrearages and disconnections. It is more challenging to collect this information, but utilities do have the ability to do this, in my opinion, and they can do so without compromising the privacy, the real privacy concerns that we have with protecting customer data. It does require a little bit more work, so that may speak to some of the cost questions that you've raised, but having this information is the only way to truly understand the disparities that occur with respect to disconnections and energy and other forms of utility insecurity. So I would strongly recommend an amendment to the rulemaking that would ask utilities to report this information at the zip code level or at the census block group or tract level to allow some leverage on what the nature of sort of the underlying patterns of these issues are across the state of Missouri. Thank you. Happy to answer any questions.
Thank you very much. I do have a question for you. You'd indicated that other states do, in fact, require the reporting of some of this information. Do you, I would say I hate putting you on the spot, but that's kind of my job. What states, to your knowledge, require that this information be reported in a somewhat similar fashion?
Yeah, it's a great question. So we have compiled this information in an online tool called the Utility Disconnections Dashboard, which you can find at utilitydisconnections.org. And this, there are about 2/3 of the states have required in some form disclosure around utility disconnections in particular. Practices around arrearages varies a little bit more than that, a little bit more spotty. But this is a pretty common practice in many parts of the country. In some states, off the top of my head, Illinois, Minnesota, New Jersey, California, zip code level data reporting is also common. So utilities have been asked to do that over some time. So that's a little bit less common, but frankly, I think becoming more and more accepted practice. So reporting around disconnections in particular is not everywhere, but for regulated utilities in these 30 or so states, it is now pretty common practice.
Okay, I have no further questions. Thank you for your time today, and thank you for your comments.
Thank you. I appreciate the opportunity.
Does Renew Missouri have any comments that they would like to offer today regarding this rulemaking docket?
Yes, thank you, Judge. Briefly.
Would you identify yourself for the court reporter?
Yes, thank you very much. My name is Andrew Linares, representing Renew Missouri. I'm the Regional Director and Senior Counsel based in St. Louis. My comments today mainly serve to echo those of Dr. Mark for the Office of Public Counsel and John Kaufman for the Missouri Consumers Council. I believe that this proposed rule, that the primary values are standardization, transparency, and timeliness of the disclosures. And on the issue of waivers, I think that waivers, when applied too broadly, can defeat these broad purposes if they're allowed to be too broad. So I would echo the comments that waivers should be tailored narrowly. I would also like to echo the comments from our previous speaker that the proposed rule is consistent with rules in other states that have been in existence or are currently being sought, especially since the COVID pandemic. And to sum up here, broadly, we don't want Missouri to be an outlier in terms of its disconnections for its electric, gas, and water utilities. We want it to be within the realm of what's consistent in the country, or perhaps even a leader. And in order to gauge that, we need standardized data across the same periods of time and data that's made easily available to the public. So I would offer our support for the proposed rule and make myself available for any questions if there are any.
Thank you, Mr. Linares. I have no questions for Renew Missouri. Are there any commission questions for Renew Missouri? Thank you for your time.
Thank you.
Now, before I get to calling individuals, because I know of at least one individual who would like to make a comment on the rule, have I missed any entities that wanted to offer comments on this rule? Okay, hearing none, it is my understanding that there is a Jen DeRose who would like to make comments. Ms. DeRose, are you available for comments via WebEx?
Yes, I am, and I am speaking on behalf of Sierra Club.
Okay,
May I go?
please go ahead.
Sure, thank you so much. Thank you all for this opportunity to speak. I am mostly here to, again, echo the comments of my colleagues at Consumers Counsel and the Office of Public Counsel. As this rule, we support this rule, but we think it could be further improved by adding the requirement to break disconnection data down by zip code. And again, the benefits of this are many, as outlined earlier, but I just wanted to add a little more context, which is that due to historic redlining, communities of color across the country are subject to hotter temperatures during the summer, contributing to their household energy burden. And this may lead to a higher chance of disconnection. So warmer temperatures are also linked to poor air quality, making groups vulnerable to disconnection susceptible to negative health impacts that can come with hotter weather. So if nonprofits focus on community health and financial assistance would be able to use that disconnection data broken down by zip code, they could target their assistance programs to areas where we know that folks are experiencing the most chance of disconnection. Additionally, standardized reporting data would allow for fair analysis of how utilities compare with one another when it comes to preventing disconnections. And that can help lead to better company policies, ultimately preventing disconnections, which is a goal I think we all agree is worth pursuing. So yeah, again, I just want to echo the comments of my colleagues and add those comments, which I also submitted online. Thank you so much for the opportunity to speak. Do you have any questions?
Now, these are the comments of Sierra Club, not testimony, is that correct?
This is my testimony in addition to the comments from Sierra Club. Apologies.
Okay, then I'm going to swear you in at this time in regard to the comments you just made.
That's fine. Thank you very much.
Do you swear or affirm that the testimony you gave at this rulemaking hearing is the truth?
I do.
And the testimony you just gave in regard to that, do you swear that that was the truth?
I do.
Thank you very much.
Thank you very much.
Are there any other individuals or entities at this time who would like to offer comments in regard to this rulemaking or testimony? Hearing none, staff, are you ready to make or respond comments in this rulemaking?
Yes, Your Honor. Earlier, we had comments about the cold weather rule, and I think that it was said that there's similar rules that mirror the cold weather rule, but similar is not the same. They are inherently different. And we demonstrated this, the possibility of duplication by stating that we'd recommend keeping the rule, but when the cold weather rule occurs, we'd like the cold weather rule to be followed as prescribed. The cold weather rule is intending on collecting information for the cold weather rule, and this disconnection rule is for disconnections. They are not the same. and that means they are not duplicative. If you like, further questions on that, well, we have staff here to answer those. But that's what I have today.
Actually, I do. I would like to hear from somebody in regard to that. Is there somebody who can offer testimony on that?
Yes, I am Tyrone Thomason. I am a senior research data analyst with the Customer Experience Department.
Would you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give at this rate making is the truth?
I do.
And I'm going to ask you to maybe scoot the microphone just a little bit closer. I was having a little difficulty hearing you. And would you please state and spell your name for the court reporter in the record, and then you may offer your comments, or you may offer your testimony.
Tyrone Thomason, TYRONE THOMASON.
Okay, I was looking at this, and because staff had filed this in EFIS, and it recommends the addition of bold language in subsection 3, where it says any utility that provides a report pursuant to this rule need not provide separate report pursuant to 20 CSR 4240-13055 parentheses 15. And then staff is recommending the addition of the language outside the Commission's cold weather rule period. During the Commission's designated cold weather rule period, November 1st through March 31st, each utility providing heat-related utility service shall file a report pursuant to 20 CSR 4240-13.055, parentheses 15, no later than the 20th day of the following month. Mr. Vandergriff had indicated that this is, while they are similar, they're not the same. Why is a second filing necessary?
Staff believes that the information that is that will be requested in the disconnect rule will kind of get at, well, there's multiple things. First, staff believes that the disconnect rule will get some of the general data, but it's not going to get some of the specifics. So, for example, I have three general categories in particular. First, the cold weather rule specific information that is in the cold weather rule reporting is not going to be picked up in the disconnect rule reporting at all. So, to give a specific example, sorry. So number 12 in our comments says under the proposed rule, utilities would not report the number of customers who requested a reconnection under the cold weather rule and were refused. So that's something that's specific to the cold weather rule that the disconnect rule does not address at all. And there are three other examples of cold weather rule specific information that would be excluded in the disconnect rule. Second thing, there's going to be less detail in the energy assistance and payment agreements that get set up and their effectiveness if we just use the disconnect rule reporting, do not use the cold weather rule reporting. So as an example for that, if you look at number 6 in staff's comments, the attachments, under the proposed rule, utilities would no longer report data on reconnections or reconnections as a result of receiving energy assistance. So we would not be able to tell how effective the energy assistance was in getting people back reconnected after they've been disconnected for non-payment. And there are 7 of those that I have counted that kind of fall into that category. The third and final category will have less detail on the circumstances, meaning why people were disconnected in the first place, and the outcomes of that disconnection. So, for example, number 13 on the on staff's comments Under the proposed rule, utilities would not report the number of customers who did not receive energy assistance. Under proposed rule, utilities would not report the number of customers who did receive energy assistance, but not enough to retain or restore service. So we would not know. We would not know if. Sorry, one moment. Yeah, we would not know if those customers who had been disconnected ever actually got their service back on. I don't believe there's anything in in the disconnect rule reporting that actually addresses reconnections per se. Those are three main concerns. To summarize, it's just a matter of, it's not only a matter of what data is being collected, it's the granular nature of that data. We'd lose a lot of visibility if we just rely on the disconnect rule and get rid of the cold weather rule. So staff just wants to make the commission aware that if we were to get rid of the cold weather rule and instead go with the disconnect rule, that would be one of the consequences of that.
Thank you very, very much for clarifying that for me. I don't have any additional questions, and thank you, staff, for letting me interrupt your comments to ask that question.
Judge, if
And
I
it
may.
appears
Oh, I'm
that
sorry.
Ms. King has some comments that she would like to make.
Apology for interrupting, sir.
And is this going to be testimony, or is this going to be just a comment or clarification?
I just wanted to add to Tyrone's comments, if that's okay.
Okay, I'm going to go ahead and treat that as testimony, so if you'd raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give at this rulemaking hearing is the truth?
I do.
Go ahead.
Thank you, sir. I just wanted to add that the cold weather reporting requires utility companies to report the number of registered elderly disabled that register under the cold weather rule. So that is currently being reported to the commission. Under the proposed rules, we would no longer receive that information. And I think it's important for us to know that, customers that are submitting that information for that registration, that the companies are accepting that. So we do find that as valuable information to know that the registered elderly, disabled, low-income folks that are getting registered under the cold weather rule, we do actually track those numbers to ensure that those folks are getting properly registered. And there is an annual registration associated with that. I think it's October of every year. So we do look at that. Thank you.
Thank you for that clarification.
Your Honor, before we move on from staff, just one more comment to add. Staff does not oppose collecting information in regards to zip code. However, if we are responsible for going over the additional data that this proposed rule may require, then staff will likely need another full-time employee. So that's another consideration.
And that would be addressing the public cost, correct?
Yes, Your Honor.
Thank you. Hold on just a second, I'm taking a note. Does staff have any other comments to offer today?
No, Your Honor.
Okay, I've got a few questions you addressed, and thank you very much for addressing that public cost comment. That was actually one I wanted to ask about. Has staff done any analysis into the private cost to the individual utilities of implementing or complying, well, not implementing, of complying with this rule?
No, Your Honor.
There have been a couple of entities that have offered comments indicating that that variances granted under the Chapter 13 or Chapter 2 variance should be narrowly tailored. Is that staff's position?
Staff doesn't oppose that position, but we're opting not to take a position on the variances.
Okay, thank you. Are there any questions for staff from the commission? Thank you. Are there any other comments that anyone wants to offer in regard to this rulemaking at this time?
Your Honor, Lindsay Van Gerpen for the OPC. I was wondering if I could address one comment that came up in the written comments.
Please, go ahead.
Thank you, Your Honor. And this is in response to, I believe it was Missouri American's suggestion on changing the time that's specified in subsections 2A and 2B of the proposed rule. Now, those provisions are aimed at trying to determine the number of residential meters that are actively receiving service at the very first part of a calendar month and the very end of a calendar month. And so in order to do that, we've specified 0000, so the very beginning of that first calendar day of the calendar month, and then 2400 of the last calendar day of the calendar month. And I believe the suggestion was to change those specific times to something like the first calendar day of the month and the last calendar day of the month. And I just would like to point out for the commission that we had originally had something closer to that, something a little more general, in our very first iteration of the rule back in 2019. We had specified only the first day of the month and the last day of the month. And then based on feedback throughout both the workshops and the voluntary case study, it came to our attention that we might need a little bit more specificity than that in order to make sure that this data was being reported the same across all the utilities. We learned that it might change based on the time of day when certain reports were run and whether it was based on a calendar month or a billing month. And so that is why we've settled on those specific times and those specific days, and also specifying the calendar month. So while we understand it may be a little bit confusing, the use of the military time there, we would ask that if the commission were to change that, to make sure that we include that specific time so that we can have that consistency across utilities.
And thank you, Public Counsel, for bringing that up. That was actually something that the Secretary of State's office had queried me about when looking at the version of the rule submitted for the register. And I had mentioned to you about it because I, too, was initially thrown thinking that 00:00 and 24:00 were, in fact, at the same time, and did find it confusing. Would it be sufficient in this case to just simply say the first minute and the last minute of the calendar day of each month? Would that be clear?
Your Honor, I think that would be fine as well, as long as it's clear, like you said, the first minute of the first day and the last minute of the last day. I think that would be fine as well.
Got 2 more comments. Okay.
Dr. Mark?
2 more comments, Your Honor. One, there was a number of utilities that responded that they may need some time to ramp up their services to provide this, and we completely understand that. You know, we wouldn't, in fact, we would imagine that the first submission of this would be a learning process for everybody. I mean, again, there was some hand-holding, but even that hand-holding's now probably been a year, you know, since, or a little less. You know, it's varied between the utilities since we've had that. So the intent of if the rules move forward and are codified, having a 2-month, maybe 3-month lag in that reporting would not be unreasonable from our opinion. The second thing, just like briefly to comment on Consumer Counsel's specific recommendations about the zip code information. And I'm speaking from experience. No doubt that adding that additional level of information may increase cost and complexity of the rule itself. I am confident that there would be a significant return on investment for ratepayers as a result of that. My experience with working with utilities, with the commission staff, the Department of Social Services, in trying to implement and facilitate funding through federal funds, through SAFER, and other funding streams that came down was a challenge, in part because we did not have the data. We did not have good individual data on a granular basis. I believe it would also complement many of our existing low-income programs, whether that's weatherization or arrearage payment programs. So to that extent, again, just to reiterate, we do believe that would be a good return on investment, especially long-term. Thank you.
Thank you, and it's my understanding that Mr. Kaufman would like to make an additional comment on behalf of Consumers Counsel. Is that correct?
Yes, Your Honor. Just briefly, on that last point, would certainly agree with Dr. Mark, and in that whatever expense we're talking about, even if it's the additional expense to break down the data by zip code, I've not heard anything more than maybe $18,000 or something to that low. Even if it's a full-time employee for each utility, I think it would be justified, given that this data is going to help the equitable distribution of millions of dollars every year in low-income assistance, in various programs. And I think that we saw during the pandemic an actual difficulty in getting the money spent out. And if we had better locational data about where maybe a concentration of struggling customers were, it would help other agencies as well as the parties that appear before the commission be able to more target that data. The other thing I wanted to point out again is relating to the transparency and public information of this. We're really happy that the proposed rule, the commission's proposed rule, does make it clear in subsection 2 that all information provided here under this proposed rule would be public information. And unfortunately, it wasn't written that way in 1977. And this relates to the request to not require it because there's some data being provided under the cold weather rule currently. And we agree with staff that those are two different purposes and two different reporting requirements. And our concern would be that this rule not be waived or deferred to that other rule, because as it's written, the current cold weather reporting data is in the minds of some people not public information. We would like to clear that up for good because we believe this really should be public information. And that's all I have.
Thank you, Mr. Kaufman. I want to clarify one issue in regard to the 5-digit zip code reporting that you were talking about. When you say worth the cost, are you indicating that you believe that if a utility had to hire a full-time employee to comply with this rule, you believe that that would be money well spent if those costs were distributed to the ratepayers? Is that correct?
Yes, I would agree with that, and I would, even though I don't think I don't think that this reporting requirement actually justifies a full-time employee, but if it did, I think it would be clearly worthwhile. And yes, it's my expectation that whatever compliance costs come out of this, it would be included in rates going forward. And there is language to that effect in the cold weather rule currently that is almost a guarantee to the utilities of recovery. And I would assume that any compliance cost with Public Service Commission rules would be considered a prudent expense. So yeah, definitely have not heard any claim that the costs here would be beyond what would be justified, I think, in this very important endeavor. And would understand that to be, yes, something that would be included in rates.
Thank you very much for clarifying that for me. And thank you for your further comments. Are there any other comments at this time in regards to this rulemaking?
One more, Your Honor. Thank you. Mr. Kaufman, piqued my memory on this in section 6 and section 5 and 6. There's references to posting this information on the commission's website. Wanted to make that clear if it wasn't from our filing that when we mean commission website, we didn't mean buried in EFIS. That was it.
And I believe it says something to the effect of on the commission's main internet page, correct?
It does. Thank you.
Thank you. Any further comments on this rulemaking at this time?
Judge, if I may,
Yes, and I'll remind you, you're still under oath, Ms. King.
I just want to respond to Mr. Kaufman's comments about the current cold weather reporting not being public information. I can't speak to how the public can access it in EFIS because my rights are certainly different as a staff member. I can get to everything in EFIS. But the way staff interprets the rule, which is section 15 under the cold weather rule, it does state that that information is public information. So I just wanted to point that out.
Thank you very much. Are there any further comments in regard to this rulemaking? Okay, then we are done taking comments about this rulemaking. Are there any other issues or matters that need to be addressed by the commission at this time? I hear none and see none. With that, I will adjourn this hearing and we will go off the record. Thank you, everyone, for your time and comments today. They're considerably helpful.